Welcome to our second lecture covering Chapter 24, which is the chapter that discusses employment and discrimination law. In our first lecture, we talked about at-will employment. We talked about three statutes, Title VII of the Civil Rights Act of 1964, the Americans with Disabilities Act, and the Age Discrimination and Employment Act. Now we're going to discuss the remedies that are available under these three statutes. These are the specific remedies under Title VII, but the remedies under the other statutes and also the Equal Pay Act are pretty similar. So let's go through them, and this is not so much to focus on exactly how the calculation is made, because that requires a little deeper dive, but just to kind of get an idea about what the buckets or what the possible categories of recovery might be. The first is back pay. Let's think about this in a timeline sense. So a bad event happens in somebody's life on this date. Well, it will probably be, okay, so from the time of the event until the time that the person, a person obviously can file a charge of discrimination immediately, but they have up to 300 days that they could file. Once the EEOC gets the charge, they may well have it for a year or longer, and then the 90-day window starts for when the lawsuit is filed. And then there could be easily another year or two before you get to trial. So as you can see here, we have the possibility of even as many as 4 years, but certainly 2 years would be reasonable to think that it would take from the time of the discriminatory event until you get a jury verdict. Well, during that time, the person who is subject to the discrimination may have either been unemployed as a result of the discriminatory act or be underemployed, meaning they're working fewer hours or they're earning less money than they otherwise would. And so it makes sense to award that person the pay that they would have earned if they had been employed during this time. And so this back pay will start on the date of the adverse employment action all the way up to the date the jury renders its decision. That's what we call back pay. And that's available under virtually any statute that we'll be talking about today. Another thing that's almost always available would be attorney's fees, and this is of course for the victor. So if the plaintiff is successful and persuades the jury that in fact he or she was a victim of discrimination, he will be entitled to his attorney's fees. The awarding of attorney's fees is a fairly unusual thing under American law. Under American law, usually both the winner and the loser pay their own legal bills. That's what we call the American rule. There's another rule, the English rule, not surprisingly, that goes the other way, that the loser pays both sides' legal bills. There's policy arguments both in favor and against both rules, but it's not really that important that you know the policy reasons. It's just important to know the rule. And in the vast majority of cases, that will be the rule in the United States. That's why it's called the American rule. But there are a few times where the law has deviated from that, usually as a result of a statute. And here we have statutes, and these statutes are kind of a one-sided English rule. And what happens is that when the plaintiff in one of these cases wins, then the defendant, the former employer, pays the former employer's attorney's fees and the plaintiff's attorney's fees. When the plaintiff loses, both sides pay their own expenses. So you can see in this scenario, the defendant, the employer, always pays its own legal bills. And depending upon the result, it may or may not have to pay the plaintiffs. So it's a kind of a combination of American and the British rule. In addition, court costs will need to be paid by whoever loses. Court costs are not nearly as significant financially as attorney's fees. And unlike attorney's fees, they're not really so much statutory. I mean, they may be technically statutory, but they're pretty much automatic. Loser always pays these. But honestly, these expenses are not huge. They probably are in the $10,000 to $20,000 range. They are things like the cost of depositions, the filing fees, the service of process fees, the jury fee that has to be paid. It's typically things that either side had to pay out to some third party in order for the case to proceed. So they're not trivial, but they're not huge, and the loser has to pay those. And the loser in this case could be the plaintiff. So while the plaintiff never has to pay the defendant's attorney's fees, even if the plaintiff loses, the court costs the plaintiff would have to pay. So these three are pretty much kind of automatics that we see in these cases. But the next two are an innovation that we see in the law. These were not in the initial version of the statutes. And the addition of these two bases for recovery significantly changed the landscape of employment law. So let me first of all explain the changes that happened, and then explain why these are so significant. The first is compensatory damages. Compensatory damages are damages that are designed to, yes, you guessed it, compensate the victim after the victim has proved that he was the victim of some kind of unlawful act. And you could say, well, isn't back pay designed really to compensate the victim? Well, of course it is. But this is a different or additional compensation above that. And this oftentimes goes towards the soft losses that a person might have. The mental anguish, the sleepless nights, the stress, those types of things that happened as a result of the employment action. Those soft numbers, you can't actually do a hard and fast calculation on those, but they're real. I mean, losing your job or being the victims of some type of harassment or retaliation can be very, very emotionally devastating, and so it makes sense that the costs that that person bears are not just the actual lost wages that they experienced. So compensatory damages can be collected. This was not initially possible, but in the early 1990s that was added as a remedy. Then we also have punitive damages. Punitive damages are designed to, yep, you guessed it, punish the defendant. Or another term for punitive damages is exemplary damages. Those are damages that are intended to make an example of the defendant so that other potential defendants will see the example of the defendant and say, I don't want to be in their shoes, so I'm not going to take that particular action. So the other term for it is exemplary. And you can see in the word exemplary the word example. These two damages together are added. The jury comes up with numbers for each one of these buckets. If this is obviously only happens if the jury finds that the plaintiff was able to prove his case. They come up with numbers here, and then the court adds the two numbers that the jury came up with here. And then there is a statutory formula for making the calculation. These two numbers can't exceed a certain sum, and the sum depends upon the number of employees that that particular employer has. The cap generally is $300,000 for both compensatory damages and punitive damages together. The back pay isn't capped. It can be as big or as small as the amount makes sense. So these are the financial damages. These are the numbers. These are, I guess you could say, legal remedies. But now we're going to talk about some equitable remedies. Let's pause for a second and reflect upon the terms legal and equitable remedies. When we hear legal, it's a good idea to think about money. Legal remedies are dollars and cents, or pounds or francs or euros. Doesn't really matter the currency, but it's something that is reducible to cash. That's what a legal remedy is. And you can see all of these categories are reducible to dollars and cents. The jury's going to come back with a number here, and a number here, and a number here, and a number. Well, actually, the judge comes up with these numbers, but these would be numbers that the jury were to come up with. They may be hard for the jury to arrive at, but they will come up with a number. These last two, though, aren't numbers. These are what we call equitable remedies. And equitable remedies are remedies that are designed to fix a problem, but without doing it, but not doing it with money, with doing some other mechanism for that. So I'll say not equal to money. There's more differences than what I'm saying right now, but for the purpose of our discussion, that's all we need to know today. So one of these remedies could be a court order, and usually this is going to be an order of reinstatement. Imagine that Bob was terminated on this date for, let's say he was the victim of age discrimination. The jury finds in his favor 3 years later, and over the course of these last 3 years, Bob has struggled financially. He hasn't been able to get meaningful employment, in part because maybe other employers are discriminating against him based upon his age. And now he has 3 years of being out of the labor market very successfully. So the prospects of him getting the kind of employment that he's hoping to attain elsewhere is probably not very good at this point. And so the court has the ability to order reinstatement. The court can make Bob's former employer hire Bob back and return Bob to the position that he was in previously. Now, that doesn't involve any pay to Bob. I mean, obviously, once Bob is rehired, he'll be getting a paycheck, but it means that the employer would have to put him back into his position. Not surprisingly, neither Bob nor Bob's former employer really likes this choice very much. It really creates a very difficult position for everyone because by this point in the litigation, Bob really can't stand his former employer, and his former employer really can't stand Bob. A lot of bad blood between those two. It's probably a pretty unsolvable problem at this point. Think about it from Bob's perspective. These are the people that has fired him, that said he was incompetent, that he was a thief, or that he was lazy, or whatever the particular criticism they had. Many of them got up on the witness stand and testified against him, and he's going to have to go to work 40 hours a week and face those people, knowing what they think of him, knowing what they did to him. That's a pretty difficult thing to kind of bring yourself to do every day. Think about it from the employer's standpoint. Now they have Bob back. Bob's won. How humiliating to have to deal with Bob under those circumstances, knowing that you fired him, but that a jury of 12 people thought that you were a bunch of bigots who mistreated Bob. You're never really going to be able to fire Bob at this point again, not after this lawsuit, so you're stuck with him forever. Bob's probably going to feel pretty entitled, pretty cocky, pretty difficult to work with and be around. It's probably going to be a real morale hit for the department because you're really not going to be able to manage him, and other people will see, well, Bob doesn't have to work very hard. Why do I have to work very hard? And others may learn Bob's story and decide, well, I'll file a copycat lawsuit. So the reality is neither Bob nor the employer really wants Bob to come back. So there's another alternative, and that is a front pay award. Now, this is money, right? I mean, it is not money, so you could call it a legal remedy, but it's intended to replace the reinstatement remedy. And so because it's really intending to replace an equitable remedy, it's also considered an equitable remedy. And so this can be a good comparison. So a reinstatement obviously would be for an indefinite period of time. Front pay would be for a certain number of years. 2 or 3 years is pretty common. You rarely find more than 5 years of front pay being awarded. So that's how the court orders work. These are 2 examples of remedies that are available by court order, but there are others. There could be training for the workforce, sexual harassment training or something along those lines. There could be requirements about notifications and things like that of employees so that they know how to contact the EEOC or things along those lines. But the most important is clearly a reinstatement and front pay. There can also be remedial seniority. Bob has been out of the workforce for 3 years. If he is reinstated, very likely the judge will make the employer treat Bob's employment as if he were continuously employed during that time. So let's say Bob on this date had worked for his employer for 12 years and he is returned to work on this date. Well, instead of it being day one of his new employment, or even the 12th anniversary of his employment, these 3 years would be added to it, and he'd be treated as if he had 15 years of employment. And that would be for everything from being on layoff lists to maybe pay rates to maybe pension eligibility and things along those lines. So as you can see, there are several generous benefits that are available here. Now, I said before that everything else here is pretty old news, but these are the two, not super recent, but more recent than the other remedies. And there's two kind of significant things that happened when these two new benefits became available to plaintiffs. The first, of course, is that this made plaintiffs, they were able to recover more money. And so this caused defendants to look upon these cases in a different way. Before this time, most people who were suing weren't in high-income jobs. And so back pay of, typically it wouldn't be more than 3 or 4 years, back pay for 3 or 4 years wasn't a huge sum of money. Even with some front pay, it wasn't typically a huge sum. You were talking, a few $100,000. I don't want to diminish that, but it certainly wasn't something that was going to bankrupt a company. But this suddenly sometimes doubled the exposure that employer had, these compensatory and punitive damages. And so it caused the employers to look upon these cases in a different way. They were now willing to invest more resources in avoiding these lawsuits because they had more of a downside risk, and also were more interested sometimes in settling these cases or in using more of their resources in defending the cases. So it kind of upped the game from the defense side. The same thing happened on the plaintiff side. Honestly, prior to these legal changes, it was difficult for a plaintiff, even with pretty good facts, to find an attorney who'd be willing to represent him because there just wasn't a lot of money to be made in these cases. You might say, but they're going to get their attorney's fees either way. Well, most plaintiffs enter into a contract with their attorney, which is called a contingency fee arrangement. And what that provides is that if the plaintiff is successful in the case, then everything the plaintiff recovers, he will have to share with his attorney. And oftentimes it's a 30, sometimes even a 40% share that he will have to do with the attorney. So what you do is you add up all of these sums, and then you take whatever the percentages that the attorney is entitled to, 25, 30, 35, whatever the number is according to the contingency fee contract. And then that becomes the attorney's payday. But of course, if the attorney and the client aren't successful and the client doesn't get any money, then the attorney doesn't get any money out of the transaction. So the attorney is motivated to represent plaintiffs only when plaintiffs' cases are pretty strong and only when plaintiffs' cases involve pretty significant damages. Well, this increased the value of the case significantly because even though the attorneys, or even though the plaintiff is entitled to attorney's fees, this isn't the amount the attorney actually gets. The amount the attorney actually gets will be all of these numbers added up times the contingency fee percentage. This is another reason why front pay is preferred over reinstatement. I don't want to sound cynical here, but attorneys can get a portion of front pay. They can't get a portion of reinstatement. So this money, the plaintiff's attorneys are going to get a share of that. And so that's another reason why that's an appealing option. Okay, so this is just an overview about how remedies work and what the factors are to consider. So as a result of adding these two remedies, many more plaintiffs' attorneys became interested in representing plaintiffs in this case. As a result, it's easier for a plaintiff to find an attorney to represent him or her in an employment discrimination case. I wouldn't say it's easy, but I would say it's easier today than it once was. So we're going to talk about discrimination theories, and there's two main theories for us to talk about. The first is disparate treatment. The second is disparate impact. Disparate treatment is what we traditionally think of when we think about employment discrimination. That's when the boss says, Sally, I don't want to hire you because you're a woman. Or Bob, I don't like to hire people of your religion. Or Teresa, your kind isn't welcome around here. When somebody just is a bigot and just is, That's what's going on. Now, in the examples I just gave, that's a bigot who is loud and proud, right? Most bigots nowadays, at least in the United States, they don't actually make it that easy for the victim to be clear. So if Bob, say, is African American, it's a pretty rare manager who's going to say, Bob, I'm firing you because you're African American. No, the manager is going to come up with some other reason. I mean, no employee is perfect, and therefore Bob won't be perfect, and so there'll be something that Bob's done that the manager can say, well, Bob, I'm firing you because X, and really that may not be the true reason. In addition, many times managers have unconscious prejudices. They themselves might not fully understand why they want to fire Bob. They may honestly believe it's because Bob was tardy several times, when in fact an aspect or a portion of why they were so offended by the tardies may be Bob's religion or his national origin or his age or whatever that particular characteristic is. So when you and I think about employment discrimination, we're probably thinking about disparate treatment situations. They aren't easy to prove, but they are conceptually easy to imagine. Disparate impact cases are a little bit more tricky. In a disparate impact case, we have a neutral policy that doesn't single out a particular race or religion or age or any of those types of characteristics. On its face, it's neutral, but in the way it actually works, it tends to favor or disfavor a particular category of individuals. Imagine for a second that there was an airline that said, we don't want to employ flight attendants who weigh over 130 pounds. Well, that would have a disparate impact on men. There's relatively few adult men who weigh less than 130 pounds, but there's a significant percentage of women who weigh less than 130 pounds. And so more men would be excluded than women. When the fire department says we want our firefighters to be at least 5'7" tall, well, again, most men are going to be at that height or taller. Most women are going to be below that height. More women are going to be excluded than men, even though the policy on its face is neutral. Generally speaking, if the reason for the policy is safety, it's pretty likely to be approved. And you can see a firefighter who might have to get into and out of precarious situations carrying a injured person. You could see how their height might be an important factor in whether they'd be able to escape or not. You can see with flight attendants, you might want them to be physically smaller because the cabin is so small and the aisles are so narrow that might make things easier if you had those individuals at a relatively small size. So there could be some business reasons for that. When the plaintiff is trying to prove disparate impact, it's not necessary that the employer intended to discriminate. Now, for the disparate treatment, it is necessary that the behavior was based upon citizenship, on that particular characteristic. But for disparate impact, it wouldn't have to be. Let's look at disparate treatment a little bit more. Let's go through the three things that a plaintiff has to prove. The first one that a plaintiff has to prove is the prima facie case, and this actually has 4 elements. The first element is pretty much automatic. In fact, really all of the first 3 are pretty much automatic. The first one is that the plaintiff has to prove that he or she is a member of a protected class. Well, as we covered before, everyone is members of lots of protected classes. If you're a human being, you're a member of at least one racial group, perhaps more than one. If you are a human being, you have some skin pigmentation. If you are a member of the human race, you are of one or the other gender. If you're a member of the human race, you are some religion or no religion, because again, agnosticism and atheism count as religions for the purposes of Title VII. If you are well, I guess you don't have to be over the age of 40, but you can see how we are all members of several categories. And a man is protected from sex discrimination just like a woman is. A Caucasian is protected from race discrimination just like an African American or an Asian would be. So that's the first thing that the plaintiff has to prove, that he or she is a member of that group. That's almost never an issue. The second thing that he or she has to prove is that he or she was qualified for the job. In the vast majority of cases, the vast majority of employment discrimination cases arise when a person is dismissed from a job. There can be failure to hire cases. They happen, but they're much less frequent. So in a termination situation, the person had already been assigned to do that job, so it's pretty much of a no-brainer that he was qualified to do the job. I mean, you could have a situation where a job's responsibilities dramatically changed. So, I mean, it's not impossible that that could be a factor, but usually there's not a lot of dispute about whether the person was qualified for the job. And in this case, the standard really isn't, was the person the most qualified for the job, but did the person have at least the minimum qualifications for the position? The third thing that is required is that something negative has to have happened to the employee. Well, after all, the employee is suing, so obviously he thinks something negative happened. And this could be the failure to hire, the failure to promote, perhaps a termination, perhaps a demotion, or a loss of a certain benefit. Again, since the plaintiff is suing, that's usually very easy to prove. So the first three, again, they're almost never at issue in being proof. The fourth one is the one that occasionally there will be a bit of a hang up on, although most of the time even this one isn't a problem. And this one is the least defined of the four. Basically what the case law says is it's got to be one other piece of evidence that points toward the employer discriminating on that basis. I'll tell you as a practical matter what that fourth thing usually is. It's usually because the person was replaced with a person outside of that person's, the discharged person's category. So if I'm a woman and I'm discharged and I'm replaced by a man, that would be a good example for number 4. Or if I am a Japanese person and I am replaced by an African American person, then that would be element 4. If the position is never filled, or if the position is filled with somebody of my same category, for example, I'm a woman replaced by a woman, then I haven't proven this element. I'm going to have to look for something else. But there are other categories that can work here as well. So the bottom line is, it's pretty rare that a plaintiff doesn't have all the facts that he needs for the prima facie case. This is usually not a very difficult thing for the plaintiff to prove. The next thing that happens after the plaintiff has proved his prima facie case is that the defendant has to articulate a legitimate, non-discriminatory business reason for the action. So going back to the example, let's say that I'm a woman who was qualified for the job, I'd done it for 10 years, who was terminated, and I was replaced by a man. So I made my prima facie case. But my employer comes back and says, listen, the reason that we terminated Groover is that she was tardy to work 10 times in the last 2 months of her employment. And we only permit 5 tardies in a year. So she was well out of bounds. We gave her all the progressive discipline. There wasn't any other person in the workforce that had as bad of an attendance record as Groover did. And so that seems to be it's legitimate for employers to be concerned about tardinesses. It's not discriminatory. Women weren't held to a different standard than men, and it's certainly related to the business. So it looks like I'm successful with this one, or not I am, but the employer is. Next, the plaintiff can come back and say, this was just a pretext. Yeah, I mean, it is true, I was tardy those 10 times, and the defendant's making a big fuss about that, but the reality is the defendant's never fired anyone for tardies ever. And they claim that no one has had as many tardies as me, but that's only because they don't keep very good records. That they've jotted down every time I was tardy, but when Bob would be tardy, they didn't make a notation. And so actually Bob was tardy a lot more than me. So in other words, the plaintiff is punching holes, either factual holes or logic holes in what the defendant is saying. The plaintiff has to first prove the prima facie case. If he can't, the case is over. Then the defendant has to present this non-discriminatory reason. If the defendant can't present a non-discriminatory reason, plaintiff wins. If defendant can present advances a non-discriminatory reason, then the plaintiff has another shot. If the plaintiff presents some evidence that's mere pretext, then the case goes to the jury. We don't know which way the jury will go. The jury might side with the plaintiff, might side with the defendant. This is a disparate treatment case, again, where there is allegations of intentional discrimination. Let's talk about disparate impact. Here we're going to have three things, and you're going to see that it follows very closely with the list we have here. One here tracks with one here, two here tracks with two here, three here tracks with three here. So let's look at number one. This is the equivalent of the prima facie case in disparate impact cases. The plaintiff is going to have to present statistically significant evidence that this neutral policy actually statistically impacted the protected class of which I am a member, since I'm the plaintiff. And so that would be the first piece of evidence. That's the prima facie case. If you know you have a disparate impact case, you're not going to file the lawsuit unless you feel like you can establish this. So the next thing is now the defendant. The defendant has the burden, just like over here, the defendant had the burden of presenting a legitimate non-discriminatory reason. Well, here, the defendant is going to have to prove a business necessity. That's the term that you use. A lot of times the business necessity will be something like public safety. Again, going back to the flight attendant. If you had a 250-pound flight attendant, maybe he or she would be blocking the aisles during an emergency and people wouldn't be able to get by and get out of the burning airplane. Or the firefighter who wasn't tall enough wouldn't be able to rescue grandma who's passed out in the burning building. And so the argument would be that there is a safety issue or a major business-driven reason why you would want to do this. Now, necessity is probably somewhat of a misnomer in this context. It doesn't mean that the business absolutely will fail unless the company is allowed to have this policy, but there just needs to be a very tight logical connection between this policy and the business interests of the company. And then, of course, the plaintiff gets to rebut it, gets to show, again, that mere pretext that we saw over here. Well, again, we have the idea of pretext. Yeah, the employer is saying it's a business necessity, but let me tell you why it's not. And so, for example, a plaintiff might challenge the rule about firefighters to show that in another city, firefighters who are only 5'5" are allowed to be employed, and there's been no increase in the number of fire deaths of either firefighters or of residents for the last 10 years, or whatever the statistics are to show. No, that's a bunch of hooey. That's not really necessary. And so that can be the next step. I'm going to show you, or the last step that has to be proven for disparate impact. If the plaintiff doesn't prove this first case, defendant loses. If defendant can't present a business necessity, defendant wins if plaintiff can't present the statistics. If defendant can't come up with a response that's a business necessity, plaintiff wins. If plaintiff can't come up with any evidence of pretext, defendant wins. If plaintiff can come up with pretext, then it goes to the jury. It could go either way at that point. Let's look at something from the textbook here. We are on page 518. There's this little table. And you can see we have disparate impact. This shouldn't be international discrimination. It should be intentional discrimination. And then disparate impact down here is unintentional discrimination. Okay, so we have the burden on the plaintiff, and you can see under disparate impact, we have that prima facie case burden. And here we have statistically significant. And then we have them have to indicate a non-discriminatory reason. Here we have the business necessity. Then the burden goes back to the plaintiff to show mere pretext, mere pretext. So they track very closely through these columns. So this is just another representation of that data. Okay, so let's talk about sexual harassment. There are two categories of sexual harassment. Well, first of all, let's talk more generally about harassment. Any category that is protected under the law, be it race discrimination, color discrimination, national origin discrimination, religious discrimination, age discrimination, sex discrimination, all of disability discrimination, all of those categories also lend themselves to harassment claims. So imagine that I'm 60 years old and I am working in a workplace, and everybody is teasing me and calling me grandma, and everybody's making jokes about, oh, grandma must be senile, if I forget something. And it's just this constant joking around. Maybe they think it's funny, but I certainly don't like it. That could be a type of harassment. Or let's imagine that I am African American, and there are jokes made about comments made about aspects of African American culture that are disparaging. Maybe negative words are used, racial epithets are used, or ugly statements are made about my ethnicity or me because of the race that I happen to be a member of. That could be racial harassment. All of the categories can result in a type of harassment, but the most common of the types of harassment is sexual harassment. So we're going to talk about that in a little bit more detail, but don't assume that that's the only type that exists. This is just one example of the harassment theory. Okay, so what is sexual harassment? Well, it's unwelcome. I mean, that makes sense. If you are enjoying the playful banter, the back and forth, teasing or flirting that's going on, it's not harassment, it's welcome. So it has to be unwelcome. So it includes anything that's unwelcome, such as sexual advances, requests for sexual favors, and other verbal or physical conduct, I don't know why I have a dash there, I apologize, of a sexual nature. So any one of these three, or combination of these three things, and then here we have our next part, that makes submission, in other words, agreeing to this, whatever this conduct is, a condition of employment. In other words, you have to do this. If you want to stay working here, you have to date me, you have to sleep with me, you have to put up with my jokes. So it makes submission a condition of employment or a factor in employment decisions, or that creates a hostile, intimidating, or offensive work environment. So there's three behaviors that we're looking at. And there's three ways it can affect the workforce. I'll call this A, B, and then this last one is C. So let's look at what the two types are. The last one really just applies to sexual harassment. So I'm going to say this is sex only. But the hostile work environment is the one that can apply really in any type of discrimination situation. So quid pro quo is a Latin expression meaning this for that. An example of a quid pro quo could be, I'll buy you that ice cream cone if you will jump up and down 3 times. Well, I said, I'll do quid, I'll buy you the ice cream cone if you do quo, jump up and down 3 times. The idea of quid pro quo isn't a bad thing. I mean, that really is just contract law, right? I'll agree to do A if you do B. That's the nature of employment relationships. That's the nature of contracts. I agree to pay you to be $20 an hour if you'd agree to work for me doing these particular tasks. But in the context of sexual harassment, quid pro quo isn't a good thing. And what it means is that a supervisor makes a sexual demand on somebody, and this demand is reasonably perceived as a term or condition of employment. Hey, you need to do X, you need to submit to my sexual advances in exchange for me doing something for you. For example, it might be date me or I'll fire you, or it could be have sex with me and I will promote you, or it could be kiss me and I will give you a favorable job appraisal. I mean, there can be lots of different levels to this relationship. It doesn't have to be actual sexual, kind of all the way type of sexual stuff. It can be something that is less, I'll say, severe, for the lack of a better term. And it doesn't have to be necessarily, I'll fire you if you don't. So it can be a positive thing, do X and I'll do this good thing, or it can be a negative thing, do X and I won't do this negative thing. So the quid pro quo is the one that applies only in a sexual harassment context. But most, or at least a fair number of sexual harassment situations don't involve quid pro quo. They are hostile work environment cases. And as I said before, other types of harassment can also be hostile work environment cases. And the name kind of suggests what it is. When a workplace has become so tense that it becomes hostile because of the sexually charged nature, that is what is a hostile work environment. It is severe and persuasive sexual conduct that permeates the work environment and interferes with an employee's ability to perform his or her job. Many times people think that a stray remark or one off-color joke is going to be sexual harassment. That is rarely going to be the case. It has to be a pervasive problem, or it has to be a single event that is really, really bad. That's not usually going to, one event or one comment is usually not going to be so significant that it crosses the line. Now, I suppose in a sexual harassment situation, if somebody starts fondling another person, that could be a hostile work environment right there, even if there's no quid pro quo involved. Or, for example, let's say I'm African American and someone puts a noose in my work chair or something like that. Something along those lines. Really extreme things a single event could be, but most of these cases it's, a million drops of water kind of constantly over a significant period of time. One or two insensitive things isn't going to be sufficient. Another thing that sometimes people aren't aware of is that the court isn't going to micromanage the work environment. The court is not going to become a nanny, isn't going to be there saying, well, that wasn't a very nice thing you said just there, or gosh, your mind is in the gutter, I don't really like that. No, the court isn't going to play nanny, isn't going to become, the Sunday school teacher in the situation. The fact that there is sexual comments being made, that it's a little bit of a salty or raunchy environment, isn't going to be sufficient to be considered a hostile work environment. Again, keep in mind it has to be unwelcome, and it has to be severe and pervasive sexual conduct that interferes with an employee's ability to perform his or her job. So this is pretty extreme stuff. We've spoken before about sexual orientation discrimination not being one that is recognized under federal law, under Texas law. So this statement down here might be a bit of a surprise. You might assume, well, if sexual orientation is in protected category, same-sex sexual harassment would not be a protected category in the law. And it is sometimes a more difficult thing to prove, but there are cases. Oncala is the big one. You don't need to know the case, but in case you're curious, I'll write the name of the plaintiff. You can have same-sex sexual harassment cases in a few different ways. Sometimes it is when the harasser experiences same-sex attraction, is either, say, a lesbian woman or a gay man. And so when he or she engages in this sexual behavior, he is expressing sexual interest in this subordinate employee. In that circumstance, sexual discrimination, the law would apply in the same way that it would if the sexually harassing behavior was done by someone of the opposite sex. So that's one category. That one's a pretty straightforward one. There's not a lot of controversy about that. Another situation could be when there's sexual harassment of a gay man or lesbian woman by people who do not experience same-sex attraction, or at least they don't identify along those terms. So this could be a way of taunting or embarrassing or humiliating a gay man or lesbian woman by making comments about their possible sexual conduct or preferences in a demeaning and offensive way. And again, this isn't so much necessarily sexual harassment. It's more like sexual orientation harassment. Sexual orientation harassment, when it's harassment based upon sexual orientation, that's not protected. But when it's about sexual things, even if it relates to homosexual conduct or lesbian conduct, that could potentially be considered sexual harassment. There's a third kind, which is a little bit difficult for me to fully understand. So I might not be capturing this exactly right, but in this situation, it would involve I think as a practical matter, it's more likely to be men, but maybe that's mistaken on my part. But anyway, people who are heterosexual who taunt someone who may be heterosexual, may be homosexual, as maybe some kind of hazing ritual or some way of humiliating them in the way that they're choosing to engage in that is through some kind of sexually demeaning attention of some type. Again, it's a little bit difficult to conceptualize. This wouldn't most likely be happening in a white-collar work environment. It's probably going to be a bit of a rough and tumble environment where that could become a issue. So anyway, sexual harassment is potentially a claim. I think that it is less easy to make than many people kind of assume that it is, but it's certainly available under the right facts, as is other harassment scenarios. Let's talk about two employment discrimination defenses. These are just two of the ones that are available. And we're going to talk about BFOQ first. This stands for Bona Fide Occupational Qualification. This doesn't cover a lot of categories, so it's a pretty small category of exceptions, but I think it's worthy of notation. These are when the nature of the job requires that a person fit a certain profile. For example, imagine that I am the CEO of the Hebrew National Hot Dog Company. For those of y'all who don't know, Hebrew National is a brand of kosher hot dogs. And while many people who are not of the Jewish faith eat the hot dogs, I'm sure that the original market was intended to be for Jewish families who kept kosher, who followed the dietary laws established in the Jewish Bible. Well, one of the requirements for food to be designated kosher is that a rabbi have ultimate responsibility to ensure all the rules are followed. Now, obviously, a rabbi doesn't have any additional knowledge about how to keep things kosher than anybody else could have. You and I, who presumably are not rabbis, would be able to learn all the rules, all the procedures, and we could, as consistently as a rabbi, make sure that those are enforced. But because there is a religious aspect to this kosher designation, an observant person of the Jewish faith would not be satisfied with me, a Methodist, or you of a different faith journey, saying that it was kosherly, that everything was kosher. And so as a result, Hebrew National has to employ rabbis to take this last step. Or take the step to confirm the kosherness of the items. And so that would be an example of a BFOQ. Hebrew nationals allowed to require that that particular position be held by a Jewish person, and not just a Jewish person, but a rabbi. But if Oscar Mayer wanted to have its hot dogs, and it wanted to have its safety or purity inspector or quality control inspector be a Jewish rabbi, but Oscar Mayer's hot dogs are not kosher, of course would say, no, that's not a BFOQ. You sure can employ somebody who's a Jewish rabbi in that role, but you can't require that. Another example would be, let's say that you were in a department store and you had employees whose jobs were to clean out the fitting rooms, to assist customers who were trying on clothes, to bring back and forth clothes to the customers. Well, under those circumstances, you might be in situations wherein you would see customers who were not fully clothed. And the idea might be that you wanted the customers to feel comfortable, maybe not being fully clothed in front of the person who's carrying the clothes in and out. Many customers would feel more comfortable being not fully clothed in front of somebody of their own gender. And so a rule that a department store could have, which is fitting room attendants have to be of the gender of the particular fitting room to which they are assigned, that would be considered an appropriate BFOQ. One thing that isn't appropriate for a bona fide occupational qualification is customer preferences. You can't say, well, our customers are bigots and they really prefer to deal with white males and when they're buying a car. And so we're not going to hire females, and we're not going to hire African Americans or Asians or Hispanics to be our salespeople, because study after study indicates that they will sell fewer cars than white males will sell. That may or may not be the case, but let's assume that there were hardcore statistics showing that this is a real thing. Customers in this particular market really do prefer a white male to be the salesman when they go to a car dealership. Even if there's all kinds of hard data out there, it's still an unlawful rule. You cannot discriminate that way, because of course, how are we ever going to make progress if we allow prejudice to continue to be ingrained? At least that's the argument there. So there aren't a lot of BFOQs, just a handful that in just those very narrow fields. Again, for the most part, things relating to modesty. Another example of the modesty thing would be a mammogram technician. Again, a man would be able to conduct the mammogram, which is a breast cancer examination. Basically, an x-ray is taken of the chest of a woman, and it involves the woman being unclothed from the waist up, and it involves the technician kind of arranging the breast on a particular plate so that a good image can be created with the x-ray. So a mammogram technician needs to see the woman without a top on, and also needs to touch and arrange the breast. Many women would be uncomfortable with a male doing that. They don't love a woman doing that either. It's not the most fun thing in the world, but they're less uncomfortable that way. So I would say an employer could say, well, it's a BFOQ, a bona fide occupational qualification, that our mammogram technologist be female. Another category is a bona fide seniority system. This is less of an issue today than it once was, say, in the late 60s or early 1970s. The Title VII of the Civil Rights Act was passed in the mid-1960s. And after that date, it was unlawful to prefer, say, Caucasians or men over African Americans or women. But obviously it had been lawful prior to that time, and so there had been times where employers, without breaking the law, had favored white males over other demographic groups. And certainly we'll say in 1970, many of those people employed had been the beneficiaries of that system. So let's assume that we had an employer who had strongly preferred Caucasian men up until 1965, and then began, completely stopped being discriminatory, hired the best person, so then they started hiring Asians and African Americans and Hispanics and women. And so the people that had been employed over the last 5 years were a very diverse mix. But of course, all the people that were hired more than 5 years ago were largely white men, and they had more seniority over this newer population. Well, the law says that seniority system can be maintained. It's not illegal, even if most of the people with more seniority aren't in the disadvantaged categories. So let's imagine this business goes through a rough time in 1972. There's a downturn in the economy. No one wants the product, and so they have to do layoffs. And let's say the methodology they used for the layoffs was to lay off the more recent hires. Well, who are those people going to be? Well, that diverse population that was employed after the Title VII was passed. And so the workforce might end up, in 1973 to be almost as lacking in diversity as it was back in 1963. And so a bona fide seniority system can be it can perpetuate past discrimination, but it will usually be enforceable. Let's talk about the EEOC charge process. There are two different paths that an employee or former employee can use, but the one we're going to focus on is the one through the EEOC. The reason that we're going to focus on that is that Texas does have its own state law system. There is a state law that protects Texans from employment discrimination that is apart from the federal statute. We don't talk about it too much in this class, though, because it doesn't provide any more protections than the federal law provides. It also doesn't provide any less protections, but it doesn't add anything new, so it's just easier to talk about the federal law. So because we have a state statute, the employee could choose to file under state law or under federal law. As a practical matter, the employees at least in the Dallas area, virtually always choose to file with the EEOC instead of with the Texas State Agency. By the way, the Texas State Agency that is our FEP, which is the Fair Employment Practices Agency, the state equivalent of the Equal Employment Opportunity Commission, is the Texas Workforce Commission Human Rights Division. The reason that that's not a very popular agency for people in the Dallas area to use is that it has only one office in Austin. So think about it. Are you really going to want to travel all the way to Austin to file your charge? I mean, I suppose you can probably do it remotely, but you're never going to have a face-to-face meeting under those circumstances. But the EEOC, the federal agency that administers all of these employment discrimination laws, has an office, in Dallas. So as a result, it gets a lot more of the business in this market. Now, if you were in Austin, you might be genuinely torn about which agency to file with. Okay, so you have one of two choices. You can file with the state FEP, in our case, Texas Workforce Commission Civil Rights Division, or you can file with the Equal Employment Opportunity Commission. The document that you file is called a charge. You've probably heard of the term charge when you're talking about, say, criminal matters. Bob was charged with a crime, that idea. Well, a charge is a similar idea, though of course it's not a criminal matter. So what you're doing is you are asserting, alleging, charging your employer with a violation of one of these statutes. It is a sworn statement, so when you sign it, you're doing under pains and penalties of perjury. So it's not a trivial thing to complete. What's the information that you need on it? Well, you need to include your name. You're the charging party if you're the employee. The name of the defendants, this will be the name of the employer, but it could also include the name of individuals, maybe your supervisor or somebody from HR, maybe someone higher up in the chain of command. And then you need to tell your story. What happened that you feel is discriminatory? Usually the story is quite short. I mean, there's just a little section, maybe a box, maybe this big, maybe you can get in 3 or 4 sentences. So, you're not going to tell an involved story, but you're going to give the nuts and bolts, the brief summary of what's going on. So the EEOC gets this charge, and then the EEOC investigates it. The EEOC here interviews you. It talks with people from the defendant, interviews various witnesses, looks at documents, and then reaches a decision. It can reach one of 3 decisions. One decision it can make is it has not found enough evidence to proceed further with the case. So it says, we're closing our file and we're issuing issuing the plaintiff a right to sue letter. We'll talk about what that means in a second. This is the first option. Another option the EEOC can do is it can say, well, we found that there was a significant amount of evidence of discrimination, but we just don't have enough resources at this time to pursue this particular matter, so we're going to issue a right to sue letter. But we're going to tell you that we think you've got a pretty good case. That's option number 2. Option number 3 is to say, we think you have a pretty good case, and we are going to represent you. We are going to litigate your case for you. So we're not going to issue a right to sue letter because we're going to sue on your behalf. So those are the 3 things that can happen. I would say probably 95 to 97% of the time, this is the one that will happen. Then this one might happen 1 or 2% of the time. This happens almost never at all. In fact, it may not even ever happen. It may be more theoretical than real. So this is the bucket that we're usually in. Let's look at what happens in this situation. If the EEOC decides not to sue, and again, this is almost always the case, it notifies the plaintiff of his or her, and of course, we call this person the charging party, that's that person right here, of his or her right to file an action, meaning a lawsuit, and issues the plaintiff a right to sue letter. What's a right to sue letter? It is a statement that the plaintiff has followed the proper initial procedures and therefore may file a suit. When the plaintiff gets the letter, he or she has 90 days to file the lawsuit. If he or she waits longer than 90 days, that window is closed, the lawsuit will be thrown out. The plaintiff cannot fix it at that point because he can't file another charge at that time. The EEOC can issue a right to sue letter immediately upon getting the charge. Many times the plaintiff will ask the EEOC to do that because the plaintiff wants to move this case on as quickly as possible. So they may say, hey, we didn't want you to investigate, just issue us a right to sue. And sometimes the EEOC will agree to that, sometimes the EEOC won't. If the EEOC actually does an investigation, that can take a year or longer to complete. So that kind of depends upon the involvedness of the case as well as what's the backlog at the EEOC at that particular time. As I said, the plaintiff can't file his lawsuit until he gets that right to sue letter. And if he never gets it, if the EEOC chooses to on his behalf, then the plaintiff doesn't have a choice. The EEOC will litigate his case. He won't have the ability to kind of dictate the course of the lawsuit. So we have completed the first category. You may recall I said this is about 85% of the litigation that we see in this area. This is probably about 10%, and this will be about 5%. So we've taken part of the bulk of this case, of this subject. Next, we'll be talking about employment laws that focus upon individual employees' rights, IERs. And then we'll talk about labor law, which again relates to unionization. So thank you for your attention. Of course, if you have any questions about the material, feel free to send me an email, come to my office hours, or raise them in class. Thanks for your attention. Have a great day.